Hi, good afternoon, guys, and welcome to today's edition of The Law and You. I am your host, yours truly, Shellon Washington, attorney at law, licensed in the state of New York, also licensed in my home country, Guyana, and in the Twin Island of Trinidad and Tobago. I welcome you to today's edition. Today, we'll be discussing medical malpractice issues. So today, we're going to be looking at cases where people are injured by a doctor or by a medical facility. And what should you do if you or a loved one has suffered any form of injury as a result of the negligence of a doctor and or a medical facility? Now, number one, I want you guys to know that not every single issue that occurs between a doctor and a patient or a patient and a medical facility could lead to potential compensation to you. But there's certain types of wrong. If a doctor or a medical facility does that, then it definitely means that you ought to be compensated. And then I'm going to tell you how you can get compensated. Now, the issue we're discussing today, please note that it's restricted to the jurisdiction that I'm referring to and not necessarily Guyana, because as you know, we don't have a specific claim in Guyana for medical malpractice, but we do have negligence claim in Guyana. So in Guyana, medical malpractice would fall under the broad umbrella of a tort, a negligence called under the umbrella of tort claims. But specifically in the jurisdiction of New York, you can claim medical malpractice as a major form of tort. It's a negligence claim. And this is a highly specialized area of law that we deal with in the state of New York. Now, let's say you're visiting a doctor and let's say you're going to a specialist for something very specific. Let's say that you believe that, your primary care doctor refer you to a specialized doctor because let's say you develop a mold on your skin and you don't know what the mold is. And your primary care doctor has run tests. They've looked at it and they said, you know what, we're going to refer you to a specialist, a skin doctor who specialize in detecting and diagnosing anything as it relates to the skin, including skin cancer. And your primary care physician sends you to that doctor who is specialized in dealing with this area of law. This area of medicine. You go to the specialist examines you, runs certain tests on you, and then at the end of the examination, the specialist determines that you're fine, you're perfectly healthy, and there's nothing else that they can do for you. They give you a clean bill of health and they told you you can go about your life. You go about your life and later on, in about a month or so, your skin start becoming worse and worse and worse to the point where it is affecting your daily life. It's affecting your quality of life. Then you develop pain in the skin and it starts to cause other issues and prevents you eventually from being able to go to work. Then at that point, you go back to your primary care physician. Your primary care doctor says, okay, I'm going to have to send you back to another skin doctor, or you can go back to the same one. You go back to the same skincare doctor who already examined you. That doctor, again, tells you there's nothing wrong and there's nothing they can do for you. But you realizing that there's something seriously wrong with you, decided that you want to get a second opinion, which is something that you should always do every time you have an issue and nobody could determine what is wrong with you. So you decide to go look for another doctor, maybe under your insurance or based on the referral of your own doctor. You go to the new doctor runs some tests, and the new doctor determines that you have skin cancer. At that point, when you recognize that you had this condition the entire time, it means that you may possibly have a claim against the first skin doctor that you went to. Now, the current skin doctor did all the examination and they determined that you had already started developing this condition even before you went to the specialized skin doctor, the dermatologist, whoever that doctor was, the first time. And they've determined that because that doctor failed to recognize and diagnose you in time, your issue has gotten worse. And instead of it being like a stage 1 that it was at the time when you saw that doctor, it's now at the stage 4. And it is possible that you may not live. At that point, you may have a claim against that dermatologist. The law allows you to sue somebody who specializes in the area of medicine, but the person failed to detect and to determine you had a medical condition at the appropriate time. They failed to interpret the test properly, or they failed to run the proper test to make a proper diagnosis of your condition. So they failed to diagnose you. And then if they fail to diagnose you as a result of that failure, your condition has gotten worse. And therefore, you need medical treatment now. You need to either take whatever form of advanced treatment that you can get for that condition. Now you're put to that cost to get that done. And maybe it's expensive, or maybe it's something that you can't do. If you, for some reason, you don't live, then your family would have a wrongful death claim against that doctor, because that doctor is considered a specialist in that area of medicine, and that doctor should have detected or should have determined that you had a problem. And the reason why I'm specialized, I'm making sure that I say specialist, is because if you end up going to the wrong doctor who is not specialized, you may not be able to claim, you may not be able to have a claim against that doctor, because that doctor don't have to, maybe the doctor wasn't sure of what they were doing because they're not specialized in that area of medicine. But as long as that doctor was specialized and should have known what he or she was doing, then you have a right to make a claim against that doctor. Another area in which you have a right to make a claim against a doctor, let's say a doctor is specialized in a particular surgery, a surgical procedure, and that doctor negligently performs that surgical procedure, in that the doctor left the surgical equipment in your body, like a sponge, or one of the equipment that they were using during that surgery was left locally in your body. If that happened, that's negligence. A doctor or whoever is performing that surgery has the right to use all caution and all due diligence to ensure that during that surgery, they take all the necessary steps to ensure that they remove all foreign objects from your body before closing up that area that they perform that surgery on. The other thing is, if let's say you have an injury to your left hand and the doctor does the surgery on the right instead of the left, again, that's negligence. That's battery, as a matter of fact, because you never consented to the doctor performing the surgery on the wrong hand. You had an injury to the left hand, and that's where the doctor or whoever is performing the surgery is required to perform that surgery, not on the hand that is perfectly normal and healthy. Otherwise, that would be negligence. It would be battery, and you would have a right to file a claim. And sometimes in some cases it might be failure to obtain the client's or the patient's informed consent if they're performing a surgery on the wrong side of the body other than the side you consented to having that surgery performed on. So these are all instances where you can file a claim against the doctor or the medical facility that performed that surgery on your body. The other thing you need to know about these medical malpractice cases is that they're very, very time sensitive. Medical malpractice case, if you know that you were injured as a result of a doctor or a medical facility, it's best if you take steps immediately to consult an attorney and make sure you get the lawsuit filed within the right statutory time. Not only that, not, like I said in the beginning of this conversation, not every single injury warrants, you getting compensated. If it's a case where you suffered some sort of injury that was correctable, and then you go back to the doctor and the doctor took steps immediately to correct the issue, and you didn't miss any time at work, you didn't have to waste any time, you didn't suffer much injury as a result of the person's failure to do something, then in that case, you probably wouldn't get compensated, because your compensation is actually based on the extent of your injury and the extent of your pain and suffering. So the longer you suffer in pain, and the longer you're not able to go back to work or to do the things that you normally do on a daily basis, the greater it is that you will be compensated. But like I said, if your injury or whatever your damages that you're supposed to get is just a short period of time, it didn't last very long, you didn't have much pain and suffering as a result of the negligence of that doctor or facility, then you reduce the possibility of what you're going to get out of that claim. So guys, make sure you know this stuff. And if you believe that your loved one was injured, or in the case of some people die in the hands of a doctor or a nurse or a medical facility who took negligent steps or failed to take certain steps to ensure that that person was properly cared for. In that case where it's a wrongful death, you would have lost your loved one at the hands of a doctor or a nurse. But just know that it depends on several circumstances, including the age of the person who died, including the health status of the person also. So obviously, if you have an older, feeble person who have multiple comorbidity, the person had, let's say they have diabetes, blood pressure, high cholesterol, and the entire 9 yards of illnesses was on that person, and that person died as a result of something that the doctor or the facility would have failed to do, the question would be whether or not that failure of the facility would have anyway resulted in the death of the person, or whether the person would have died anyway because by virtue of their age and the other medical conditions that the person had. But if the person was otherwise healthy, they were controlling the blood pressure, they didn't have anything else wrong with them really, but it was just the negligence of the hospital or the medical facility that caused the injuries, then they're entitled to compensation. Case on point, a lady was staying in a hospital, a client was staying in a hospital, and this lady had a history of falling. She was disoriented. She was, of course, elderly, but she didn't have much going on with her health-wise, other than her blood pressure, which was well controlled. She was otherwise fine. The hospital left the woman sitting in a wheelchair with no restraint, and the patient got up or attempted to get up out of the chair. She was not attended to. She was not well attended to. No one paid attention to her. They knew that she was not mobile. The doctor made certain comments to the deceased, telling the deceased that she needs to try harder to walk, because she went into the hospital walking. She was fine. She was healthy. But as a result of some negligence that the hospital did, the client developed some sort of perforation to the intestine, and the perforation resulted in a rupture in the intestine because of the negligence of the hospital. Then they rushed to do emergency surgery. After the emergency surgery was done, the client, which was at the time she was a little bit 71 or 72. She wasn't that advanced in age. She lost her equilibrium. She couldn't balance herself no more. So she couldn't be mobile after that surgery. I'm not sure how that happens, how a surgery takes a person's balance off, but she was no longer able to balance herself, so she couldn't stand. The hospital, knowing these facts, left the woman sitting in a wheelchair unattended with no restraint whatsoever. The woman attempted to get up, fell on her face, broke her nose, she bled through it. And then at the end of the entire thing, she just deteriorated after that fatal fall, and then she died. In a case like that, if you have a loved one who something of that sort happened to, you're definitely, or the estate, because in this case, the woman definitely died. In that case, her estate is entitled to compensation. And I'm going to tell you this, if you have a loved one who died and you believe you have a wrongful death claim against a medical facility or a doctor, just note you want to be within the statutory period, the statute of limitations. And number one, you need to apply for letters of administration, because if that person dies intestate or testate, let's say they die leaving a will, whoever is going to be the executor need to rush to file with the probate court to obtain letters of testamentary, or in a case where the person left no will, it's going to be letters of administration. You have to rush in time to get that done, because if you fail to do that, nobody will have authorization to bring that claim on behalf of the estate. Remember, it's the estate's claim. Whoever is entitled to that estate is going to be entitled to that claim. But because the estate must be the one bringing the claim, it means they must be appointed an executor or an administrator to file that claim quickly. You cannot sit and wait, because, as long as you get that authorization, that letters of testamentary or letters of administration, then you could rush to file a claim for wrongful death on behalf of that estate and get that sorted out. It's really important that you take those steps. First, get authorization. Secondly, after you obtain that authorization, you move to file a claim against the medical facility or the doctor who is responsible for the death of your loved one. And just keep in mind, I want you to bear in mind that in a case where you're filing a wrongful death claim, now, you've got to be familiar with all of the facts and the circumstances surrounding the death of your loved one, because you're going to be whoever it is, the family, the relatives who took care of that person, who visited them at the hospital. They're the one who's going to testify, in addition to the doctors who are going to be the expert witnesses on behalf of that estate. The star test or the star witness in a case like this is obviously going to be considered the expert witness. So your expert witness is likely to be the expert doctor who's going to testify on behalf of the plaintiff, who is the estate of the deceased person. Okay, so bear that in mind. Medical malpractice is one of the most expensive areas of law, because number one, you must, from the jump, from the go, you got to establish that the hospital was negligent. And how do you establish that? That is established through what is called an expert witness. That's another doctor with the same specialty must swear to an affidavit saying that they reviewed the file and they know that the doctor failed to comply with the requisite standard of care. Now, guys, I want to remind you that today's edition of The Law and You is brought to you by the Washington Law Firm, which I'm the owner and founder of, and my firm is located at 455 Utica Avenue in Brooklyn, New York. Bear in mind, guys, we're specialized in medical malpractice. We specialize in other areas of tort, landlord and tenant, and divorces. Divorces are also one of our second biggest area that we practice, in addition, apart from tort and medical malpractice, guys. So if you need any of those types of representation, don't forget the numbers on the screen, 718-877-3100. I encourage you to share the live, press the like button, and support us in whatever way. We appreciate you. I appreciate all of those of you who've been from time to time watching the show, clicking the like button and sharing, pressing the share button. Guys, if you don't share, the right audience will not be able to get the message. So I appreciate all those of you who continuously share and support Washington Law Firm. We are one of a very small amount of Caribbean-owned firms in the state of New York, in Brooklyn. So I encourage you to continue to support and press the like button. Thank you so much, guys. Today's edition was only meant to be a short edition today. Usually it's a half an hour show, but today, because I'm speaking about medical malpractice, guys, I'm not going to go to the full 30 minutes today. There's just a few areas in medical malpractice, or a few issues that I wanted to highlight to the public, so you will know that if you suffered at the hands of a doctor or a medical facility, you need to take steps now to either sue that doctor, sue that hospital while you're within the statutory period. And just note, as I told you before, not every wrong is a compensatable wrong. So there's times when we've reviewed files from patients. Just note that we always have to refer the files to a doctor. A doctor has to look at the file and tell us whether or not there's negligence. In the case of a bed sore or anything involving like a fall in a nursing home, those are usually nurses. So we'll have to get a nurse who is specialized in nursing home care and bedside care to review the file. And the reason why this type of case is so expensive, because we have to pay those experts up front. So just note that not every single case is going to qualify for us to take it and to move it forward, because if it doesn't have sufficient substance, if it lacks enough evidence to show that there's a certain type of damage or a certain type of injury to the client, then we wouldn't be able to move forward. There's some cases that are so obvious that you deserve or demand compensation. And then there are others, like they're borderline. Like the borderline cases is like, for instance, there's one instance where a patient was claiming he was injured from a keloid surgery. But on reviewing the records, on reviewing the file, what happened is the patient, he said he went in and he came out the same. There was no type of injury, no visible injury, no pain. He wasn't suffering from any type of pain that was causing him to lose work or to suffer much or any form of damages. And just note that every single claim is quantifiable in damages. So if there's no damages, there can be no claim. There always must be some form of damage in order for you to establish your claim against anyone, guys. Okay, so just bear that in mind. Anytime you want to move forward with a medical malpractice claim, just know that it has to be quantifiable in damages. Whatever damages you think, pain and suffering or loss of wages, in the case of a spouse, loss of consortium, all of these are ways that your damages are quantifiable. So keep that in mind. No damages, no claim. Okay. So if you suffered for a day and you weren't in no type of pain, let's say the surgery failed and the next week the doctors rescheduled the surgery and it's successful the next week, but you really didn't suffer anything. You were already on leave for that surgery. So you didn't lose any income. You didn't lose anything. So there's not much that you gain out of that. Okay. And then there's the other types, the flip side of that, where people suffer tremendous pain and suffering, and they will never be able to do the things that they did before the injury. In that case, that person is probably going to qualify for a large lump sum amount of damages, because they're likely to need medical care for the rest of their life, and they likely will not be able to work for the rest of their life. So that's why the lost wages claim is always important in medical malpractice cases. Medical claims for future medical, that's also something that is always considered in these medical malpractice cases. There's different types of damages, all quantifiable based on the injury you suffer, the length of the injury, the nature of the injury. All these factors are very, very important in determining and quantifying your damages. Okay, guys. Again, guys, I want to say thank you so much for joining me today on today's edition of The Law and You. Just remember, I'll be here again next Saturday at 4 p.m. so we can continue to discussing legal issues that are affecting you, the public. Okay, so join me every Saturday, and don't forget to press the like button and share the live as much as you can. Thank you for your support. It's because of your sharing of the link and the likes and the support that is what keeps us bringing these editions to you, so you can learn how to navigate the system with the help and the information provided on these shows. Thank you so much. And I look forward to seeing you again on Saturday at 4 p.m. for another edition of The Law and You. Do enjoy the rest of your weekend, guys. Thank you so much. Enjoy. Thank you.